Welcome everyone to the presentation on what is arbitration, a beginner's guide. Today we will dive into the world of arbitration, exploring what it is, how it works, and why it's an important alternative to traditional litigation. Introduction. Arbitration serves as an alternative dispute resolution method, which means it provides a way to resolve conflicts without going to court. This is increasingly relevant in today's fast-paced world where parties often seek quicker and less costly solutions to disputes. Understanding arbitration is vital for anyone involved in business or personal agreements as it equips you with the knowledge to make informed decisions where conflict arises. So, what is arbitration? In essence, arbitration is a structured process where a neutral third party, known as arbitrator, resolves a dispute between two or more parties. This process can be binding or non binding, but typically the parties agree in advance that they will accept the arbitrator's decision. One key feature of arbitration is its binding nature, meaning that the decision often referred to as award is enforceable by law, much like a court judgment. Additionally, arbitration proceedings are generally private, allowing parties to keep sensitive information out of the public eye, which is especially important in commercial context. Now let's break down the arbitration process into 5 main steps, which provide a clear pathway for resolving disputes. Step 1. Agreement to arbitrate. This often occurs when parties include an arbitration clause in their contracts. For example, a construction contract might stipulate that any dispute will be resolved through arbitration. Step 2. Selecting an arbitrator. The choice of arbitrator is crucial. Parties may select an individual with specific expertise relevant to their dispute, such as construction expert for a construction-related issue. Step 3. Pre-hearing procedures. This phase may involve preliminary meetings to establish timelines and procedures, and the exchange of documents that will be presented during the hearing. Step 4. The hearing. During the hearing, both the parties present their case, including evidence and witness testimony. This setting is typically less formal than a courtroom, which can lead to a more relaxed atmosphere. Step 5. The award. After deliberation, the arbitrator issues an award which outlines their decision. This award is binding, meaning it must be followed by both the parties. Now let's explore some significant benefits of arbitration. The first being speed. Arbitration is generally faster than litigation, which can take months or even years. This speed can be crucial for businesses that need to resolve disputes quickly to maintain operations. Second is cost effectiveness. While arbitration still incurs cost, it typically involves lower legal fees and quicker resolution times, resulting in overall savings for the parties involved. Third is confidentiality. Unlike court proceedings, which are public, arbitration can keep sensitive information private, protecting business interests and reputations. Flexibility. The arbitration process allows parties to choose their rules and procedures, tailoring the experience to fit their specific needs. Expertise. Arbitrators often possess specialized knowledge which can lead to more informed decisions. For instance, a dispute over technology patent might be arbitrated by an expert in intellectual property law. Despite its advantages, there are common misconceptions about arbitration. So, myth 1 is arbitration is always unfair. This misconception stems from concerns about bias. However, arbitration is designed with safeguards to ensure fairness, such as ability to select impartial arbitrators and right to appeal under certain conditions. Myth 2. Arbitration decisions cannot be enforced. On the contrary, arbitral awards are recognized and enforceable under the New York Convention, which provides a framework for enforcing arbitration agreements and awards internationally. Now, when is arbitration used? Arbitration is frequently used in various contexts, including business disputes. common in contracts, partnership, and commercial transactions. For example, if a supplier fails to deliver goods as per agreement, arbitration can provide a timely resolution. International disputes. As globalization increases, so do cross-border transactions. Arbitration provides a neutral ground for parties from different jurisdictions. Consumer agreements. Many companies include arbitration clause in service agreements like credit cards or subscription services, which can streamline dispute resolution for consumers. In conclusion, arbitration is an essential method for resolving disputes that can offer significant advantages over traditional litigation. By understanding the arbitration process, its benefit, and its common misconceptions, individuals and businesses can better navigate conflicts and choose the most effective means of resolution. Thanks for your engagement today.